Hi, my name is Robert Hetzler, and I'm often asked, after doing thousands of quadros over the last several years, or decade actually, I'm asked, Robert, what is the most common problems that you see when you receive a settlement agreement or a final judgment or something and have to put a quadro together? There's several that actually come to mind, but one of the ones that kind of comes to mind because it happens so frequently is not naming the correct name of the plan. And I've drafted up an example here on the board. I'm not sure if you can see it, but I'll read it to you. An example of something that I see quite often that's completely incorrect is, as a provision, is the husband's retirement plan and the wife's retirement plan shall be divided equally. If I have that provision in there, I really don't know what types of plans are being divided. I don't know if a husband has one plan, 2 plans, 3 plans, 10 plans. Don't know how many plans the wife has. It's really impossible to tell. And probably the most problematic part of that is that if ultimately it is discerned that the husband has multiple plans or the wife has multiple plans, and whoever has the multiple plans, the other party only has a single plan, then you have a situation where the party with the most plans will take the position of, I just meant I had one 401k to add and evenly divide it against the other party's 401k, for instance. And obviously the person with only the one plan is going to take the position that, no, my spouse had multiple plans. We meant all those plans were subject to the distribution. So as you can see, by not naming the plans within the document or the settlement agreement itself, it can cause quite a problem just inherently because you don't know what plans are being divided. Some of the easiest ways to figure this out and avoid this is just find out the names of the plan. There's 3 easy ways to do that. Well, the first one, and again, I'm not sure if you can read it, is I've got written down here is discuss with current or former employees or employers. It's very easy to pick up the phone, especially if it's your client, and find out what plans are in place. Now, if it's the other party's client or opposing counsel, you may ask them to do it, or you have some of the subpoena powers or discovery powers, but get in touch with current and former employers, because a lot of times people switch jobs multiple times during a marriage, and they accumulate several different types of plans. And most of the time, the clients are not necessarily intentionally deceiving you. They just think that they have the 401k, a defined benefit plan, because that's the type of plan, or defined contribution plan, because that's the type of plan that they see come out of their paycheck. A lot of times they don't see the defined benefit plans, the ones that are going to mean like a pension where they get a set monthly amount upon retirement. They don't see those come out necessarily on their W-2 or on their paycheck stuff, so they may not know about it, and sometimes they don't know if they're vested, or they get that statement, they don't know what that means, and it goes in the trash. Anyway, a lot of times when they switch employees or employers several times throughout a marriage, certain plans are left there and they don't know that they still exist, and ultimately they do exist. So getting in touch with all employers that the participant or your client had during the pendency of the marriage is one of the most important things to do. The other thing I have written down here is discussion with the TPA. That's called the third party plan administrator. Basically, that's the person who administers the plan. Sometimes larger companies will outsource that, but medium-sized companies to smaller companies, and if it's real small, it could be the CEO himself that does that or herself that does that. Medium-sized companies typically will have at least a department that deals with that, but even the larger ones will have it completely outsourced to a company. Either way, make contact with the plan administrator, the TPA, find out what's going on, what plans are in place for a specific employee. Because remember, a start date for one employee can mean a different set of plans than a former client that you had that worked for the same employer that had a different start date. So just don't go by past knowledge of maybe a prior client you had, because different start dates can certainly have an impact on the type of plans or how many plans or what plans are in place. So contacting them, and you'll often be surprised how friendly they are. I know that they have a bad reputation for not being cooperative and not providing information, not making information readily available. But in my line of work, I find them to be relatively cooperative because they want it to be done right the first time. Because there's so much second and third tier level of litigation now with these plans, they're actually frustrated too. They want the attorneys, they want the quadro preparers, they want those people, all those people involved in the divorce process to get it right the first time. So a lot of times without a subpoena, without any type of deposition, you can get a lot of good information. And the third and most important thing that I have written down here is get the SPD, Summary Plan Description. That is by far, I cannot stress how important that is. Every single divorce, if there is a retirement plan in place, you need to get the SPD for the plan, for both your client and for the other party. If it's your client, they can usually call the Human Resources Department and get that for you. If not, you should be able to call and get that as well. But if it's opposing counsel, certainly you want to add that into your discovery request or interrogatories or whatever methods you have at your disposal to get that. But the summary plan description for each individual plan now. So if a participant has 3 prior employers and several plans within each employer, you may end up with 7 or 8 summary plan descriptions, but they're so critical. Now, as part of our process, we're going to go ahead and secure that, but you really need to have, we're usually involved after there's already been a settlement agreement or a final judgment. So unfortunately, at that point, even if we get the summary plan description, we find out some impossibilities, it may be a little too late to go back and correct an error without additional litigation. So get the summary plan description as part of the discovery process, and that will tell you what can be done, what type of plans are in place, because I've seen a lot of cases where parties think that they're getting a lump sum amount upon the final judgment of divorce, only to find out it was a defined benefit plan, and that isn't even available to them. So it's very important to do that. So I think if you follow those 3 steps, you can avoid one of the most critical errors, which is not using the correct plan name in the final judgment or divorce settlement agreement. And I know a lot of times judges don't write them up. They require the litigants or the attorneys for the litigants to actually draft out that final judgment. So take the extra and additional steps and find out the exact plan names so that the plan names can be listed in the agreement. And here's why. One final thought is, an example here is I have example ABC Corporation 401k plan or ABC Corporation Qualified Pension Plan. And the very reason is a lot of the plan names actually kind of disclose, or it's inherent in their name, what type of plan it is. So obviously if it's ABC Corporation 401k plan, then you know it's a defined benefit plan, or a defined contribution plan, I apologize, and then you know that you can, there may be cash available, lump sums available right away at the, once the quadro is implemented. Or if it's ABC Corporation Qualified Pension Plan, then you know it's not a plan where usually there's going to be a lump sum payout, it will be a benefit over time. Now we'll talk about this in another video, but that does not mean that the quadro or the Qualified Domestic Relations Order or the Domestic Relations Order should not be implemented right away, because there are certain things that you need to be aware of when it comes to defined benefit plans, especially dealing with survivor benefits and things like that. A lot of different timing issues there, and we could spend an hour just talking about that. But anyway, I just wanted to answer that question because I've prepared thousands of quadros and been asked by hundreds of attorneys over the years. One of the common mistakes or errors, and I think this is one of the biggest ones, is just not taking the extra time to name and find out the name of the actual plans that are being divided, and not only just the names, but what plans are in place. And again, if you have several employers, and you may have several different types of plans. I hope that helps, and I look forward to seeing you in the next video. Thank you.